is kind of these game theoretic models about these incentives to produce evidence or present evidence, and how a decision maker should try to make an inference about the evidence that the decision maker sees, right? So this is, in some ways, kind of could be thought of as modeling the decision that a court would make, right? It could be thought of modeling the decision a parent might make, or a teacher, or someone in a similar situation who has to resolve a dispute, right? Maybe between two students, between two siblings. Right now I only have one child, so I don't have to think about that, and she's too young to have any disputes with siblings anyway. But if you thought about any kind of situation like that, you could model it. Obviously, there are limitations to the modeling process, right? The way we construct models is to make some assumptions, to let us think about the things we think are the most important, right? And we focus on those. And certainly you will see that in this paper that I'm going to present, that I'm going to focus on some pretty specific features of interrogation and try to get some insights from that. But excuse me. But the kind of focus on these important features lets us get some strong predictions, right? Instead, I tried to include everything that might possibly matter, then I wouldn't be able to get good predictions, right? So I realized there are some situations and some things where a game theoretic model may not be the best way to think about a strategic situation, but even in those, I would suggest it can give us some insight. But certainly a lot of situations, this will give us a lot of insight. And I hope you think what I present today gives some insight. So, excuse me, drink of water. So what I'd like to do is tell you just a bit more about some of the kinds of things I've worked on, some of the kinds of things I'm interested in, and then present this paper to you. So I've thought broadly just about, well, how would you design the kind of interaction between two parties to a dispute to have a third-party decision maker, right? And this third party could be a court, right? It may not be, but it could be a court, right? And the players could say things, they could present evidence, and so on. And I've thought about, well, what would the optimal design for their interaction look like, right? And have thought about what kind of meaning could we attach to what they say, and that really depends upon the evidence that the parties have, right? As you know, people can make kind of cheap statements, right? The people in disputes often say things, but what really matters is what they can substantiate, right? That it's not so much about what they say, but it's what they can prove, right? And it's also not so much about what they know, it's about what they can prove, right? Going back to this example of the dispute between Professor Del Granado and me, if this hypothetical dispute, if he knows that I haven't been working on this project and he cannot prove it, that's different than if he knows that I've been working on this, I have not been working on this project and he has evidence of it, right? And by evidence, it could be he has witness testimony, it could be he has some documentation that he knows I've been traveling a lot and surfing and not doing work. It could be that he has documentation of this, that he has, video recordings, he has witness testimony, he, has documentation of my travel, so on. Things like that we could think of as evidence, right? And obviously on the legal side, there's a huge literature and case law and so on what is the proper procedure with evidence, right? And some of my work has dealt with that, right? And in fact, the paper today looks a bit at the law on interrogation, and we'll get to that in a bit, right? So I've been interested, some of my other works compared adversarial and inquisitorial legal systems, right? So I am somewhat familiar with the more civil law kind of court procedure, right? And I'm not taking a position on which one is better, which one worse. They're slightly different, but I think they're still aimed at the same thing, right? And one of the things these legal systems are aimed at is settling incentives in primary activity, right? So if we thought about this hypothetical dispute, right, and that's going to court, right? Well, one thing might be that the court wants to find the truth, right? And that is an important aspect. But another thing is that what the court does should shape our incentives, right? That it should give me the incentive, potentially, depending upon what is going on and the kind of contract we have and so on. But under some circumstances, at least, it should give me the incentive to work on our project that I've agreed to work on, right? That's part of why we have laws and we have courts, right? So also, we think about other laws, right? Criminal laws, right? The reason we have those laws is we want to shape people's behavior, right? And the legal process and the court process is at least in part about shaping people's incentives in that primary behavior, right? That we want people not to commit robbery or commit murder and so on. And how that process plays out is really important for shaping incentives for people not to do that, right? And I would suggest that the evidentiary component of these proceedings, of court proceedings, is an important component of kind of getting this right to shape people's incentives in a way that we as a society want to, right? So I hope that you'll agree with me and see some of the importance of this, right? So it, in some ways, is a narrow area in that it looks at, I've been looking a lot at evidence, not all of my work, but a lot of it. But it also is really important because it underlies a lot of what the legal system is about, right? And I think has important implications. So I'm really interested in policy questions. I would agree, I think Mexico is going through a really exciting time at the moment, kind of having a chance to change the way the legal process works for any country would be very interesting, right? I mean, perhaps that would be interesting in the United States, right? I mean, there are lots of things where I think people would suggest, oh, it'd be nice if we could change this to maybe make it more efficient or make it work better. And I think, those are really hard questions, how to do that and what's the best way to do it. And certainly the focus, my focus isn't the only way to think about it and aren't the only important considerations, right? Anytime anyone's changing laws, there are lots and lots of things we need to be concerned with, right? And I think those typically, a good way to do that is to have input from a lot of people who think a lot about these, as well as people who are simply affected by these changes, right? And obviously a lot of this is from practitioners, right? From practicing attorneys. Practicing attorneys see this. As an academic who is not an attorney, I think about one area, and I think a lot about that, and I think it's important. But input from a broad range of people with varying, expertise in a broad range of areas, I believe is really important. So I think it's exciting, and I hope it turns out well. And obviously, if there's any input I could give, or if any of what I've worked on would be helpful in that direction, I think that would be great. I would be really excited about that. Okay, so I think I will go on to the paper that I'm going to present. And this is a pretty simple paper in terms of a game theoretic model, but I think it's still useful to have the model, right? Because at least for me, let me think about aspects of this kind of question that I hadn't really seen before I wrote down a model, right? And that's the real reason, at least for me, and I think most economists who do theory want to write down a model, right? It's not because I just want to work out a neat math problem. It's because I have a practical question that I think is important that I understand, and I want to go through a way that's going to help me understand it, right? So that's what this exercise is about. And I think the intuition and the kind of practical understanding is really what is important. It's nice if everything if all of the math that you work out is correct. Being really careful to do that's important. But the end of the day, the practical implications and the kind of qualitative implications are what I really want to understand. Right. So this paper's on interrogation and evidence fabrication. So the basic idea here is that, at least in the U.S. and in Canada and other parts of the world, and I suspect in Mexico, I actually am not sure of the exact procedures in Mexico, but I suspect this fits very well with Mexico as well, that when police arrest someone, that they can lie to that person, right? So if you've watched any of the popular U.S. police shows, that you see this all the time, right? The police have caught someone who they are convinced has committed a crime, and they interrogate this person. And they often aren't completely truthful with the person they have in custody, and in fact, they often lie to them, right? They often say, well, we have this evidence, or we have this witness who will testify against you, or so on. And in the U.S., that is typically protected, right? So I'll walk you through a case that kind of got me interested in this question in just a bit to give you a bit more motivation. But so I was interested in this because in the U.S., at trial, the prosecution or the state cannot lie or fabricate evidence, right? And in fact, they're required to disclose all of their evidence to the defense. So I kind of wondered, well, why is it when we get to the litigation phase that we don't allow lying, and in fact, we make the state be very generous with disclosing the evidence it actually has? Well, then why would we allow police to lie, right? And let me be clear, this isn't about what's moral or about what's, any other kind of sense of, that honesty is good, right? I think it's good for people to feel that they can trust the police, right? So this isn't about some kind of reputation story or so on. This is just about the kind of information side of things, right? Is it helpful in terms of how we get information or what we get the accused to do to allow police to lie, right? So this is about, is it good for police to lie and potentially get someone to confess to a crime, right? So that's what I'm going to look at. But before I get into that, I'll give you an example that I found very disturbing. Happened around 2002 and was covered quite a lot in the LA Times, right? So this was in the LA area. A member of a gang called the Vineland Boys was accused of murder, and the basic scenario was that this 16-year-old girl, Martha Pueblo, was at home at her parents' house, and one of her friends and her friend's boyfriend, this guy Christian Vargas, drove to her house at middle of the night, and were trying to get Martha to sneak out of her parents' house and go off and do whatever 16-year-old. The boyfriend, I think, was early 20s or late teens. He was a bit older. Whatever they might want to do in the middle of the night. And so they pull up and they park on the street outside of her parents' house. And Christian stays in the car while while the other 16-year-old girl goes to Martha's bedroom window and knocks on the window. And while they're talking, they hear a gunshot, and they realize that Christian has been shot. And so the police show up and everything, and it was a terrible situation, but Martha was not helpful with the LA Police Department. So she may have had a sense of who did this, but she didn't identify the shooter. She didn't provide them with any information. But two LAPD detectives who were investigating the case told this guy who went by Peps that she had picked him out of they have these books they call a six-pack that's kind of the usual suspects and have their photos. So if somebody, a potential witness says, whatever, that's where they start, right? Instead of a lineup, that they just have this book with, this folder with photos. And so they showed this gang member, who they knew was a gang member, his picture, and they had circled it and written Martha's initials next to it, and statements to the effect of that this is the guy who shot my friend's boyfriend. And it was a complete fake. They didn't, she didn't cooperate at all, and they completely fabricated this and showed it to him. So he goes back to jail, he gets to make a phone call, and he calls another gang member and tells this gang member that they need to do something about Martha, right? So Martha was shot and killed outside of her home by another member of this gang, right? So the LAPD had not told Martha or her parents that they had lied to this gang member. They had done nothing to protect her safety, and they actually hadn't even realized that this guy had made a phone call telling another gang member to take care of her, right? So they found out about the phone call later after it had been properly translated, and the major thing, other than this terrible outcome of an innocent 16-year-old girl being shot because she was not protected, which I think, due to a lie that police told a gang member. Another thing that I kind of took away from this was, they lied to this accused criminal, right? And this is protected, right? So it's been protected, it's been upheld by many court decisions that police have a right to lie to people they have in custody, right? So this got me to thinking, why do we allow this, right? So if you've had a look at the paper, I'll just also say a bit more about this. So it actually turned out the guy was convicted, that they found but he wasn't convicted on this. He was convicted because they found the murder weapon and tied it to him. But before they did that, they had someone else in custody they were relying to as well. And that guy spent, I believe, several months in jail, and he was finally let off because he could prove that he wasn't where he was accused of being, because there was video footage of him at an LA Dodgers game that his attorney spent a lot of time getting the camera footage from security cameras at the baseball stadium, and eventually got him let off. I believe he's accused of this or of the shooting of Martha. That it may be the shooting of Martha. It's been a while since I've read this, but I have a discussion of it in the paper. So that's really pretty interesting to me that this happens so often, right? So I was initially pretty disturbed by this. That I didn't like the idea of police lying to suspects, and it also troubled me because I think of a lot of police are trying. I would like to think we're trying to do the right thing, right? We're trying to protect people. I obviously understand there are some corrupt police, but I didn't want to look at this as just, the police always lie to people, you can't trust the police. I would say after pursuing this line of research more, I would probably be much more careful if I were questioned by police, but I'm also much more appreciative of the job they have to do, right? I think I always appreciated the job they have to do, but I'm much more appreciative of this part of it, right? And understand, I think, some of the tensions they have better, right? So what I was interested in was developing a simple model that let me think about this, right? And I started off just wanting to think about them being able to lie, and this being done to induce somebody to confess. And I have on the slides here in anticipation of leniency, right? So often there's at least some anticipation of, if you confess, that there's going to be leniency, right? And if you watch police shows, there's often even a promise of leniency, right? And it may not necessarily be a promise, right? It could be very much a plea bargain kind of story, but it could also just be some implied leniency, right? And people in the legal psychology literature who have been especially concerned about what's known as Miranda rights in the U.S. So in the U.S., if someone is arrested and accused of a crime, they're supposed to be read their rights, right? So there's this famous case where this wasn't done, and so and the person was named Miranda. So this has been really looked at in the U.S. and the case went to the Supreme Court. And this is so if you watch any of these U.S. TV shows, when somebody's arrested, right, they start off by saying you have the right to remain silent. And go on, right? Well, so the right to remain silent is a constitutional right in the U.S., right? And certainly if I were advising anyone about, what to do if they're hassled, if they're stopped by police, if they're questioned by police in the U.S., is, that you do have that right to remain silent, right? So there's a big literature in the legal psychology direction that's looked at false confessions, right, and been really concerned about the interrogation procedures that police use. And a lot of police in the U.S. and Canada use a technique that is advocated by, that's called the Reed technique. That there's a consulting firm and, kind of police and so on consulting firm that has spent a lot of time perfecting an interrogation technique and does a lot of teaching this, and they have several books on it. Just to be clear, this isn't a criticism of their interrogation techniques, right, or the interrogation techniques that police use, but I have in mind this really careful analysis of this lie-on component. And so the reason I'm kind of diverging in this direction is to talk a little bit about this anticipation of leniency, right? So the legal psychology literature that's looked at this has tended to find that even where there aren't explicit promises of leniency, the people who confess are anticipating leniency, right? So I just want to be clear, I'm not modeling this in any kind of behavioral way or, kind of saying, well, why do people think that? I'm just assuming they do, right? And if this is maybe the biggest criticism someone could have of my model, then I'm not specifically modeling this. But I don't think it adds to the analysis, and that's not really the point I want to look at, right? So I'm just saying, well, the legal psychology literature has said this exists. I believe them. I'm just going to assume people who confess or who are being interrogated either directly or just by kind of this process somehow form some sense of they're going to be receiving some leniency in their punishment if they confess. And I think that's a reasonable assumption. You may or may not, but that's the way I'm setting this up. Okay, so I'll give you a brief look at my findings, and then I'll go through the setup. So again, this is just based on inducing guilty to confess and innocent to not confess, right? This is what we want, I think. This is what I think a good interrogation process would lead to. That you get the guilty people to confess, the innocent people, I don't think we want them to confess, right? And I think innocent people confessing to crime isn't a good outcome. Whether it's that they go on to trial, and I'm going to model that they don't go on to trial if they've confessed. I'm just going to have some punishment. I could model that. But certainly confessing to police and having a signed or recorded confession has to hurt your chances at trial, right? There's been lots of research on false confessions in that direction, right? That as long as there's a false confession that can be presented as evidence at trial, that really hurts you, even if you after making an accused, after making a false confession, decide to go to trial, that having made that confession, even if you're innocent, that still hurts your chances at trial. So my basis for this, for my analysis, for my comparison, just to ask, can we get, does this help with what I think we want interrogation to be about? I think interrogation is about getting guilty people to confess and not getting innocent people to confess. I think if you talked to any of the people who work for Reed and Associates, they'd tell you that's what they want as well, right? That they want to get guilty people to confess. And they want to not have innocent people falsely confessing to crimes, right? I think they would also tell you that they don't want to even interrogate innocent people, right? I think they would tell you that they want police to be trained in a way that they only interrogate people who they are really convinced are guilty, right? And I'll talk a bit more about that in a minute. So based on this, there are some cases where allowing police to lie can be helpful for getting guilty people to confess, right? And I'll flesh this out a lot more in a bit. But it can also be harmful because you could also get innocent people to confess, right? So there's a tension here. And what this exercise is about is exploring this tension, right? And kind of looking at really what kinds of, what properties of evidence should we let police lie about, right? When is it likely that allowing them to lie is helpful, and when is it likely that allowing them to lie is harmful? And then I'm going to look kind of briefly at how this fits with what the U.S. law is on the subject, right? So in some ways this is very applied. It's still doing a model, and I'm going to try not to talk much at all about math and just give you some intuition for the setup. And hopefully I've given you some intuition about what the trade-off is now, but I'll develop that a lot more as we go on. Okay, so you don't need to worry too much about the notation, but I do want to make sure you follow the timing of things, right? So the idea is, think about this is somebody, A's the accused, P's the police. To kind of keep it straight, I'm going to tend to refer to the accused as a male, the police officer as a female, right? So the accused is going to be he, the police is going to be she. So the accused knows whether he's guilty or innocent, right? So this person knows whether he's committed the crime or not, right? So I'm just using G and I, guilty or innocent. The police officer is going to observe some event, right? So this could be, say, a witness saying, I saw this person. This could be some kind of other evidence, right? And if it occurs, we're going to call that D. If it doesn't occur, that's going to be N, right? So the police doesn't observe guilt or innocence, right? Only the accused knows whether the accused is truly guilty or truly innocent, right? And I'd point out this is a good reason to look at these kinds of questions with a theoretical model instead of trying to do some empirical work where I look at data, right? Because I could look at data on convictions and confessions and things like that, but I can't observe in the data whether this person is really guilty or innocent, right? I can observe the finding if they go to court, but that doesn't necessarily tell me whether they're truly guilty or innocent, right? There are certainly, unfortunately, innocent people who are convicted of crimes, and there are guilty people who are not convicted of crimes, right? So the third part is kind of geared towards the interrogation. Now the police officer can make a statement, right? I should back up though. This Q is important, right? And the only thing that's going to be important about this is that's the probability with which the police observe this event, right? So we would probably want to think this is related to whether the accused is actually guilty or not, right? So if I'm guilty of robbing a store, it's a lot more likely, I would hope, that someone, that I would be on the security camera footage for that store with a firearm robbing a store, right? Robbing that store. If I'm innocent, I would hope it would be really unlikely they could get footage of me doing that, right? That's maybe an extreme example. A witness saying she saw me do that may be more likely to not be 0 or 1 probability, right? It may be more in the middle, right? And the kind of evidence I have in mind here is not complete proof that the person committed the crime, right? So I actually don't have in mind, video footage of the person committing the crime, right? Instead, I have in mind more of an intermediate kind of evidence, right? That contributes to the court possibly finding this person guilty, but doesn't prove that this person's guilty, right, beyond any doubt, right? So that's not the kind of evidence I have in mind. I have in mind the kind of evidence that would help build a strong case against the person, not the kind of evidence that by itself would be the kind of bulletproof case. Okay, so then after observing the whether she has the evidence or not, the police officer gets to make a statement, right? And we could think about this as just making a statement about whether she has the evidence, right? And she's going to make this statement to the accused, right? So the notation there is just saying that we could have a cost to making the statement, right? And the reason we may want to think about a cost, and I'm not going to focus too much on this, as one of my results in a bit will show, I don't think it's that important to focus on, because if we think about police potentially having a cost to making a statement, right, saying we have this evidence, that cost is going to be pretty cheap when police actually have that evidence, right? And there is some cost associated with it because, I mean, realistically, police, for small crimes, don't spend that long interrogating people, right? They're busy. They have a lot of stuff they need to do. They don't sit for hours with somebody accused of shoplifting or something like that, right? That they may interrogate the person for a really short amount of time, right? With higher profile, more serious crimes, they will spend a lot more time interrogating somebody. But so there is some cost in that sense, but there may also be a cost, say, to put them together, this six-pack and circling this person's photo and write on a fake statement next to it. Right? And some of that cost may just be the time to do that. Some of that cost may be that they don't really like to lie to people, right? I mean, if I were in that position, I may be kind of uncomfortable doing that, right? And it may, I may not be that good at lying, and I may have to kind of, spend some time getting mentally prepared to do that. And I don't know if I'd be convincing anyway. But, so there may be that kind of cost as well. So then after that, in part, at period 4 on kind of the timing, the accused chooses whether to confess or not. If the accused doesn't confess, it goes to trial, and there's a cost for both the accused and the police officer to going to trial. And the accused is found guilty with some probability. And I'll say a bit more about that probability function in just a minute, but the probability depends on both whether the person is actually guilty or innocent and whether this evidence actually exists, right? So if the accused is right, so we're going to make this assumption about the probability. So in words, what this says is whether the accused is actually guilty or innocent matters more than whether the police have this evidence, right? So if you look at how I've arranged that, the highest probability of being found guilty is if the person's both guilty and this evidence exists, right? Then, if the person's guilty and the evidence doesn't exist, right? And then after that's innocent in the same way, right? So the idea here is, and I think this is a reasonable assumption, if we think, this isn't really a smoking gun kind of evidence, it's not, a piece of evidence that critically proves guilt beyond a reasonable doubt, but is more a piece of evidence that could be used in building a strong case. I think this is a reasonable assumption. right? Whether the person's actually guilty, which may imply lots of other evidence is there, whatever, as the case progresses, right? Because often people are interrogated early on in the case, and then that could even lead to more evidence coming out, or it may be just as police have more time to work and even prosecution, the prosecutor, the attorney, the state work on it, that they develop more, they find more evidence and they develop a stronger case, right? So that's the kind of thing I have in mind here. So there's going to be a punishment, and I just have H, R, and 0, right? So the idea is H is the highest punishment, and R is the reduced punishment, and 0 is there's no punishment, right? So the accused is found not guilty, punishment 0. If the accused confesses, he gets this reduced punishment, is my sense, it's the way I'm modeling it. And if the accused is found guilty at trial, he gets this high punishment. So we're just assuming H is the biggest, R is in the middle, and 0 is the lowest. So here's some more kinds of setups that'll make this tractable for us. We're going to assume that the police officer's only concerned with a conviction. She's not so concerned with the length of time. So this is a payoff function, and I'm not going to worry too much about the details of this. We're actually going to simplify it a bit, but what we have in mind is that the police are going to be concerned about whether there's a conviction or not, and the police want this person convicted. And to say a bit about this, to substantiate this a bit, I'm not saying that police want everybody they talk to convicted of a crime. The practical motivation for this is that typically the way police interrogate, at least in the U.S., is that they kind of interview people or talk to them before they actually do the interrogation, right? And they really should only do this kind of full interrogation of people of someone who they are pretty convinced is guilty, right? If they just see somebody and they're talking to them, they shouldn't be doing this hard interrogation where they're saying we have this evidence and so on, right? The early stage of the interaction, more collecting information, interviewing the person when they talk to them, so on, and then they only interrogate people who they are really sure are guilty, right? And this is the technique, my understanding of the technique that's typically taught to police officers in the U.S. and Canada and other parts of the world. One other reason I think this is a reasonable story is that in the legal psychology literature, there's been a lot of looking at how good people are at detecting lies and how good they are at gauging whether someone's guilty. And there's been a literature that's looked at both how well trained police officers do at telling whether somebody's lying to them versus someone who's untrained, and how sure they are that they can detect lies, and also a similar study with guilt or innocence, right? So these are set up in an experimental way. One is where they actually have somebody who is lying or not lying. It may be recorded, and then these subjects are asked to pick whether the person's lying or not, and also are asked, how sure are you about this? And a similar line of studies has been done where there's showed testimony or interrogation of somebody who has been asked to do something, right? This person before they're interrogated does whatever it is, and then they're asked whether they did it in an interrogation style format, right? So this isn't really an actual criminal, but it is somebody who's done this and they know that, and they are actually being interrogated for it. So those studies have found that people trained as interrogators don't do that much better than, this is a summary of those studies, don't do that much better than people who aren't trained, right? So they compared them to college students who hadn't been trained, college students who had been trained. They didn't do that much better, but they were way more confident in their judgment of it, right? So this, these, people doing the research said, well, this may be a problem for false confessions, right? So I'm not really taking a stand on that, but I'm saying, given these studies they've done, I think it's reasonable to assume when the police officer gets around to interrogating this accused person, I think it's reasonable to think she wants him convicted. She wants him to confess, right? So that's what I have in mind here, right? It's that kind of setup, and I think it's motivated by the studies we've seen in the legal psychology literature. Okay, so the accused obviously wants less time compared to more time, right? So one simplification I should point out is I'm assuming that the cost of going to court's just this K, right? And it's positive. And I'm actually going to get some results in a bit that show we don't really need to worry too much about that. Lastly, given all of this, the accused, given the message or, what the police say to the accused could have an updated belief about his chances should he go to trial, right? The accused knows whether he's guilty or not. The police tell him something, and the accused can gauge whether he's guilty or what his chances are at trial, right? And I think this happens, right? I mean, this is certainly what the kind of saying, we have this evidence against you is geared towards doing, right? It's geared towards getting the accused to say, well, maybe I'm not going to do that well at trial, right? So this idea here is, we first off want to just think about, well, what cases, where do we want to look for this to be an interesting question? Well, for the police's statement to matter, it has to be that the accused would be influenced by what the police has observed, right? If the police officer has this evidence, and so if the guilt, if the accused, if the probabilities are so bad, right? So the accused prospects at trial are so bad that he would be willing to confess regardless of whether this evidence existed, then it doesn't matter if the police lie to the accused, right? Or if the accused thinks his chances are so good at trial that it doesn't matter whether police have this evidence or not. Then we don't care if police lie to the accused, right? Because it doesn't change what the accused wants to do, right? So if I'm, say hypothetically I'm accused of a crime, I know I'm innocent, and I feel my chances at trial, the probability I'm going to be found guilty is really low, then I don't care what this police officer tells me, right? Then that's what the statement about the probabilities is saying, right? So just to be clear, all of these are negative, right? All the terms. The V of R is the payoff of the reduced sentence, right? So that's a negative because the accused gets a negative payoff from being in prison. I mean, I think most people do. I certainly would. So you get some jail time. That's not good. So likewise, so the Z's are negative. So all of these terms are negative. But the idea is, if it doesn't matter to the accused whether police have this evidence or not, then it doesn't matter to the accused, it doesn't matter for the accused's decision whether police lie to them or not, right? That's all the statement's about, right? So it's saying we have to be in this range where, probability-wise, where what the police observe matters to the accused, right? So that's what I've written there. So here's the first result that I'm going to use to simplify and not think about a costly, cost of police making statements. So the idea is if it's costly for the police to make if it's costless, right? So police can just make statements regardless of whether the police have actually observed this evidence. It's no cost. Then the police will lie or fabricate, right? Unless the accused decision isn't influenced by the police's statement, right? So if we think about it this way, right? So this is just based on what could be an equilibrium, right? So suppose the police tell the truth, right? That can't be an equilibrium in the setup, right? Because if I know the police always tell me the truth and I'm the accused, and in one case, when the police do have this evidence, I say, well, that's going to be kind of bad for me at trial. I'd be better off to confess and get this kind of reduced sentence, right? Then if the police know I'm doing that, then the police would want to lie even when they don't have that evidence, right? Because the setup here is the police think this person's guilty, right? And they want him convicted. So they might say, well, yeah, we don't have this evidence, but we're pretty sure he's guilty, so we may as well lie to him so he will confess, right? So we can't have a case where the police tell the truth in both cases, right? So then kind of the setup would be, well, they're going to lie in the case where they don't have it, right? And here I'm kind of attaching meaning to what they say, right? And I think that's intuitive, right? In a more technical setup, we might think about, well, what do the statements police make? How do they correspond to the evidence they've seen? I'm not going to worry about that. Just think about, when the police say they have evidence, the accused thinks that means they have evidence. So we're not going to have a case where police don't lie to this person unless it doesn't matter for the person, right? So if instead I'm just saying, well, my case is so good, I'm sure I'm innocent, whatever, or, the probabilities aren't in that range we just looked at, and the accused just won't confess, then in that case the police could tell the truth because it doesn't matter to what the accused does, right? So it's kind of a narrow range where this matters, right? But I think these are the cases where police interrogate, right? I mean, if the case is really good against, really strong against this person, then they would confess, right? If they think they'll get a reduced sentence. If the case is really weak, then police shouldn't be interrogating that person anyway, right? So I think that's a reasonable, reasonable to focus on this class of probabilities. So the last statement is if we added a cost to lie, it's not really going to matter much for the police's decision, right? It's just going to be when it's cheap enough or, when it matters enough to them to get this guy convicted relative to the cost, they'll lie. And when it doesn't, they won't. Excuse me. So that may change things a bit, but it doesn't really change things for what we want to look at, right? We would just have to add a bit of cost to that. But it's not so important for what we're looking at. So I'm just going to focus on the case where there's no cost, right? We could look at it more generally. I don't think it adds a lot to thinking about this question. Okay. So again, what I think socially desirable is that the guilty accused confesses, the innocent accused does not confess, right? right? So the last statement, what I mentioned before, even if we thought about an accused who confessed going to trial, we certainly should think of that hurt on the accused who has confessed chances at trial, right? So it may not be that everyone who confesses to a crime doesn't go to trial. Sometimes they do, but I sure think the expected payoff of someone going to trial after confessing has to be worse for them than had they not confessed, right? So I think the setup I'm looking at may not get this little extra bit of, well, what happens when they go to trial after having confessed, but that's not my focus here. So I'm simplifying it in this way. It's worth pointing out, I think I had on a slide earlier, I'm also thinking about the accused here just looking at expected payoffs, right, and deciding what to do. So in some ways, right, so that does assume the accused is risk neutral, right? If we think the accused is risk averse, then we could model that, right, by how we specify the payoffs. That's kind of an added complication. It could give us some insights about, well, how do, are some accused more risk averse than others, but the risk aversion of accused criminals isn't my focus so much. It's with this paper, it's more about, well, can we think about when police lying to suspects could be helpful, and can we think about when it could be harmful, and can we say something about the kinds of evidence police should be able to lie about? So there again, I think keeping things a bit more simple is useful in this case. Okay, so the way I'm going to do this is to do a simple comparison between the case where police can lie and the case where they are not allowed to lie, right? And just look at what we get, right? So this is going to focus on whether, one type's going to condition his decision on whether the police have the evidence, right? So if you think about this, right, the way we've set things up, if the innocent accused is concerned, if police having this evidence would matter for the innocent accused deciding whether to confess or not, right? And to be clear, I think innocent people can be coerced into confessing. I don't know how often it happens, but I am convinced that there have been innocent people who have confessed to crimes, right? And I think that's a serious problem. But if it is the case that the innocent person is weighing his chances, then the guilty person in that case, given the punishments and everything, right? So this, the punishments and the anticipated reduction in punishment are part of what's motivating this person to decide whether to confess, right? So if the innocent person is saying, well, if I knew the police didn't have this evidence, I would not confess and go to trial. But if I knew they did have this evidence, I would confess because I'd rather do that than go to trial and given my expectation of being found guilty, then the guilty person should confess, right? Given the probability, the structure, the assumption I've made on the structure of the probabilities. In that case, the guilty person would automatically confess, right? Likewise, when we're in the case where the guilty person is weighing his options, weighing whether the evidence really exists, the innocent person should not confess, right? Given my assumption on probabilities. Okay, so, right, so given the assumptions, right, that we're going to have the police always lie when the police can lie, right? We worked that out in the previous result. So when the police are allowed to lie, they always do, and the accused won't get any information, right? The accused says, well, they told me they have this evidence, but I know the police lie, so I don't trust the police. That doesn't give me any more information, right? So, as an aside, police in large urban areas, and especially in high crime areas, do have an issue of people don't trust them, right? If you, talk to police in New York City about high crime areas, police in LA, one thing that police departments have worked really hard to try to do is build trust in those areas, right? Even with honest citizens, right? So, was a big focus of New York City's, kind of broken window police policy, to have more police officers on foot in high crime areas, trying to forge real relationships with both young potential gang members and other people, their families, just, average, honest citizens in that area. So I would suggest that when, if you think about people accused of crimes, it may not be that far off for some of them that they don't believe the police, right? Certainly if you're thinking about gang members and people like that, I would say they don't trust the police, right? So I think this kind of fits with that. So the other case, those when police are not allowed to lie or fabricate evidence. In that case, the accused gets information, right? Because the police will present the evidence when they have it. So when that evidence is there, the police present it, and the accused knows they have it. But when it's not there, because the police are not allowed to lie, the accused knows they don't have it, right? So this may be slightly different for the way information might be conveyed than one might think about it, just kind of thinking about, well, should police be able to lie, right? But this is kind of an equilibrium approach, right? And we're thinking about, we get this by thinking strategically, right? By the accused thinking, well, if police can lie and they want me convicted, they're always going to lie to me, given the assumptions of the model. Okay, so we're going to start by thinking about the innocent accused, right? And we're just thinking about the case where whether so the punishments, the probabilities are such that the innocent accused is saying, I'm concerned whether police have this evidence, right? If they do, I'd be better off to confess. If they don't, I'd be better off to go to trial, right? And as noted before, in this case, right, the guilty would confess, right? Regardless of whether police had the evidence, right? So in this case, when it's not allowed, when lying's not allowed, right, the innocent type will do exactly what we've said, right? When they have the evidence, the innocent type will confess. When they don't have the evidence, the innocent type will not confess, right? And then when lying or fabricating are allowed, then the innocent type's just going to use expected payoffs, right? Because the innocent type doesn't get any information from what the police say, but the innocent type can think about, well, how likely is it they have this evidence, given that I'm innocent, right? And that's what the Q specifies in the expected payoff over there, right? So the innocent type doesn't know what police have for evidence, and the innocent type just says, well, there's some probability they have this evidence, and there's some probability they don't, and I know I'm innocent. And so I know what that probability is, or I could think about what that probability might be, so on, and I can decide whether to confess or not. If the probability is high enough, makes my prospect at trial bad enough, I'm going to confess. If the probability, if that Q is such that my expected payoff at trial is good enough, then I won't confess, right? That's all this says, right? So again, we want the innocent type to not confess. So what I have here is, and this is a mathematical expression, is that we can just use that and divide this into two cases, right? When it's harmful and when it's helpful, right? So the first line is just a rewrite of whether police have this evidence matters to the innocent type's decision, right? It's just a rewrite of what was on this line. Whoops, sorry, I'm going the wrong way. It's just a rewrite of what was on that slide. Right. So then the other two are kind of rearrangements of these two. And I'm not expecting you to follow what I've worked out for that. It's a simple calculation. If you sat down and did it, you would likely be able to do it pretty quickly. But I'm not expecting you're going to see it really quickly. But the idea is, in some cases, if we allow lying, this will induce some innocent people who would not have confessed when lying wasn't allowed, right? So if we think, back to what we had here, right? So the innocent type will confess following D and will not confess following N, right? So when it's helpful is when it induces the one that would have confessed, right, following D, to not confess, right? So the idea would be police lie, the innocent accused says, well, I can't really attach any meaning to that. If they told me it was D, that, they did have this evidence, I'd confess, but given that it's not that likely they do, I'm not going to confess, right? So in that case, letting them lie and be confusing or, not provide information to the accused is helpful because the accused is innocent and the accused doesn't confess. If on the other hand, which is the first line of when it's harmful, or the middle there where when it's harmful, if on the other hand the accused says, well, if they don't have it, I'm not going to confess, and they don't have it, but because they can't credibly convey to the accused, police can't convey to the confused that they don't have the evidence because they lie, right? And given their incentives, they lie because they think this person's guilty. Then the accused says, well, I know they always lie. I don't know whether they have it or not. I'm going to look, just think about what I think my chances are at trial, given what this Q looks like, and I'm going to go ahead and confess. Right? So in that case, we get an innocent who wouldn't confess if they had to tell the truth, who does confess. Right? So these are the kinds of trade-offs we have. Right? It's about by allowing police to lie, they don't convey any information to the accused. And in some cases, when the accused is innocent, it's maybe better that the accused doesn't know whether they have this evidence or not, right? Because if the innocent accused knew they did, the innocent accused would confess. But because police can lie, the innocent accused doesn't find that out and doesn't confess, right? In that case, it's helpful when thinking about the innocent person. It's harmful, though, if the innocent accused would not confess when they don't have the evidence, but doesn't learn that they don't have the evidence because the police lie and the innocent accused doesn't get that information and says, well, I think my case is kind of not, it's not going to be that good, so I'll go ahead and confess, right? So that's the kind of tension we have. And we have a similar case for the guilty person, but it's just the opposite because we want the guilty person to confess, right? So if we're in the range where the guilty person cares whether police have this evidence, in that case the innocent person will not confess, and we can do exactly the same kind of thing, right? In that case we might have a guilty person who says, right, I'm not going to go through all of the same thing. I'm going to just remind you what the result would be and how it's different. In that case, we might have a guilty person who says, well, if they don't have the evidence, I'm going to trial. And if the probabilities and payoffs and everything are such that if the police lie, so the guilty accused doesn't know whether they have the evidence, and it's such that the guilty accused says, well, it's likely enough that they have this evidence. I don't know if they do, but it's likely enough, I think my chances at trial aren't going to be that good, so I should confess, right? In that case, it's helpful. But it's harmful if instead we were in the case where they don't have the evidence, it's harmful in the case where we allow lying and that leads to the guilty accused not seeing that they don't have the evidence and confessing, right? So the guilty accused says, well, I would confess if they have the evidence, but the guilty accused doesn't know because they are allowed to lie, then and that leads to the guilty accused not confessing, then that's harmful, right? So these depend on obviously the values of the payoffs, right? And that's what this first observation's about. The values of the payoffs matter, right? So if we take everything else as given, these probabilities and the kind of high punishment, so again, these are negative, right? So we're thinking somebody goes to prison, that's a negative payoff, right? So we're thinking of those as being a negative. So I'm thinking about absolute value, right? So, talking about big negative numbers can get confusing, so I'm talking about absolute value, right? So if there's not much of a reduction in the punishment, then there's less scope for being in the range where lying's harmful. Bless you. Put another way, if the value of the punishment following confession's high, then we're let's see, did I say that right? I think I said that right. Right, so the idea is right, that if we give too big of a reduction, right, so if accused anticipate a really large reduction in punishment from confessing, that's more likely to get innocent people to confess, right? If you're innocent, you're accused of something, and they say, well, you could potentially get a life sentence in prison, but if you confess, we'll give you, we'll fine you $500 and make you do a month in jail. There may be a lot of innocent people who would confess in that case, right? So this result's not necessarily surprising, but it lets us think a bit about the relationship between these payoffs, in these sentences. Right, so the other results are a bit more, the other observations, which all of these kind of play off of these two results I showed. So the other ones are geared towards, well, what evidence should we allow police to lie about, right? So at least in the U.S., just to give a bit of scope for why I'm interested in this, at least in the U.S., right, there's not a clear guideline of police can lie about this, this, and this, right? I'll say a bit more later about the way courts have ruled, but kind of the sense would be if you're interrogated and you think, if somebody confesses, that's often when these cases come up and, later says, well, I'm innocent, or perhaps, there's some, technological change in evidence, which has happened in a lot of cases that people have looked at for false confessions, right? So DNA evidence has proved really important in a lot of cases in recent years for people who confessed to violent crimes, maybe 20, 30 years ago in the U.S. And there's been, a lot of work and several high-profile cases where people have later been found, after spending 20 or 30 years in jail, have been found not guilty of a crime, right? So, these may come about in that way, and later there's an issue taken with how they were interrogated, or it may be that just at trial, there's some attempt to make a confession not be admissible or something like that. The courts may come back and look and say, well, can we look at what police lied about and think about whether that was appropriate, right? So that's why, one of the reasons I want to think about what we should allow police to lie about. The other is that police are trained in these procedures, right? As I said, there's this well-known read technique, which is pretty clear about what they would encourage police to lie about and suggest they not lie about, right? So I'll say a bit about both of those angles a bit more after kind of defining this beta and just thinking a bit about properties of evidence that we may wish to allow police to lie about, and then things they shouldn't lie about, right? So you can kind of see I came from starting this project saying, well, I'm not sure I think police should lie, and I still, it still kind of gives me, I like honesty. But I'm a little more after, really getting into this, a bit more, struck by that police kind of not showing their cards can be a good thing. And I'm viewing, in some ways, lying a little differently, right? That if police are interrogating someone and they say they don't say they have anything, that kind of isn't very conducive to them getting a confession, right? At least if the accused knows they have to tell the truth, right? Because that's basically saying we don't have any evidence against you. So and again, I think the job of police officers is tough, and I have a lot more empathy towards allowing lying, right? And I can see where, from this information standpoint, it could actually be really helpful. But I think for it to be helpful, we have to be very careful about what police can lie about, right? Just giving police free rein to lie about any kind of evidence, I think, is extremely problematic, right? So this lets me think a bit more clearly about what kinds of things do I think police should be able to lie about. And it's still not going to get us a list of, well, they can lie about these and they can't lie about these, right? But it helps us kind of get to some guidelines. Okay, so the way I'm defining this beta is, right, so the X is either going to be I or G for innocent or guilty, right? But it's just a difference in the probabilities, right? So probability, if the accused is found guilty, if they have the evidence, is the XD, the probability the accused is found guilty. If they don't have the evidence, is the row of XN. And we're just going to use that to think about, kind of how wide are these probabilities, contingent on given guilty or innocent, contingent on whether they have the evidence, right? So in some ways it describes how convincing the evidence is at trial, right? So first observation is the evidence is persuasive against both of them, right? So if we thought about this beta being large for both of them, right, then there is more scope for lying to be helpful by inducing the guilty to confess, but there's also more scope for it being harmful by inducing the innocent to confess, right? Because it affects both of them in the same way, right? In this case, right, if you convince the guilty to confess, it's also convincing the innocent to confess, right? But if instead it's more persuasive against the guilty and maybe easily refuted or even easily known to be untrue by the innocent, then lying can be pretty helpful, right? Because it's not going to, it's going to induce the guilty to confess, but won't induce the innocent to confess, right? So in this case, right, if, and this may even matter for how we view things, right? And this will, get to some of the rules and so on in just a minute. But if I'm accused of a crime and I'm innocent, so I just blanketly, I hope I'm innocent of any crime. But in this example, I'm innocent of this crime, and that's kind of a joke. But in this example, I'm innocent of the crime. I know I'm innocent, and police, tell me, oh, we have, videotape of you, robbing a store. Well, on the one hand, I might say, well, maybe it's somebody who looks like me, and I'm worried about it. But on the other hand, maybe I say, well, they have to be lying, right? There's no way they have that because I wasn't there, right? So kind of those features of evidence are going to matter, right? So I'll talk a bit more about that in just a minute after this other observation, and then we'll get into kind of some practical discussion. So now if we just think about these cues, right? So the cues are, right, these are the probability that the evidence exists, right, given whether the accused is guilty or innocent. Right, so the probability that the evidence exists when the accused is guilty is a lot bigger than the probability with which it exists when the accused is innocent. There's more scope for lying to be helpful, right? So by inducing the guilty to confess and the innocent to not confess, right? Because in this case, right, thinking back to our results, when police lie, when they're legally allowed to lie, the accused aren't really getting a lot of information, but they're basing it on the probability they have this evidence, right? So if they say, we have really good evidence against you, and I say, well, I'm innocent, I think it's unlikely that that's true, then it's not as likely to induce me to confess. But if I'm guilty and they, lie and say we have this evidence and I don't know whether they really do or not, but I'm guilty, so I think it's pretty likely they do have it, right? So some of this has to do with how probative the evidence is, right? Because we might think of having a really high probability of having the evidence when the accused is guilty, and a really low probability of having it when the accused is innocent, is meaning it's pretty probative evidence, right? So this is maybe the kinds of things police should be encouraged to lie about, and they should not be encouraged to lie about things that don't happen, right? So here's a bit on the fit with current law, right? So there is a distinction made between lies told about evidence and what has been referred to as manufactured evidence, right? So it is different if police say we have DNA test results versus they show the accused a fraudulent lab result test. If they draw blood and whatever from the subject, or and then wait a couple days and come back with a printed out what looks like a lab result, that's probably very different, right? Because the one, just saying we have evidence is lying, and it's pretty clear they could make that statement regardless of what they have, and it seems pretty likely that, being able to say that fits. But actually having the results may be viewed differently, right? An accused may say, well, they do have results, and then I'm innocent, but, these 13 strands or whatever they look at for DNA test, right? And it's worth being clear, right, that even for DNA test, they're not looking at all of the, I'm not a, that kind of scientist, I guess, so I don't know the total number they could look at, but I believe they only look at about 13, right? And, given the probabilities with which you would come up with a match for somebody just randomly accused of a crime is, or, that you would have supporting evidence to go along with them having committed that crime, that makes the probability pretty high, right? But maybe just looking at randomly for somebody who has those 13 indicators they look at for these kinds of tests, I believe it's 13 is the number I'd seen, that's a lot different, right? So, for any of these, I'd suggest, that having other evidence and, being really sure this is somebody that the crime fits with matters, even if they do a real DNA test. But showing that you have this fabricated one and, somebody saying, oh, well, I guess they got those to, guy match on those, and they have this other evidence that goes along with it, that may be really concerning, right? And they may think their chances at trial are really bad, right? So I think these distinctions are important, and I think they fit with some of the findings that I've looked at, that I've just presented. The other thing that's often looked at by courts is the coerciveness of lies, right? And my read of it as someone who doesn't have a JD and is not an attorney is that it's not especially well defined, right? It's kind of, the court may know what it views as coercive, and that may fit, right? I mean, one sense of coercion may be that you're forcing people to confess, or forcing, kind of saying, well, if you don't, you're going to get this terrible sentence and whatever, and that may be viewed as coerciveness. Or confess and, we'll make sure you get a $500 fine and do a month in jail versus a life sentence, right? Well, in that sense, was really low sentence or punishment, and that being promised by a police officer may be viewed as being coercive, right? And to be clear, I think the training that police receive typically is to not make promises about sentences, right? I do think the literature that I've seen on this suggests people still infer leniency when they're being when they're being interrogated and asked to confess. But, to be fair to police, I don't think, I'm sure they're not trained, at least in the U.S., to offer really low punishments and say they can ensure that. But so that would be one avenue that may be viewed as coercive, but it may also be that presenting evidence that's just too fraudulently or too strongly, or if it really did exist, kind of focusing on that could be viewed as coercive, right? And in that case, it may fit with my findings, right? But So again, these aren't applying to some particular piece of evidence, right? Because the scenario varies so much, right? If you thought about, trying to say, well, you can't use, X as evidence, to lie about for police interrogating, there may be scenarios where lying about that wouldn't be unreasonable, and there may be cases where that particular event could be really critical, right? So maybe it's a lie about somebody being at a particular place at a particular time, and if there's a murder that happened at that place, I'm not sure this is the best example, but that they went to a restaurant to buy food, and right next door there was a murder, right? Or they were seen at that restaurant. In one case, that may be really coercive, or may really matter to how they view this, the strength of it, and how it fits with what I've identified as potentially a helpful lie versus a harmful lie. But in another case where that's not a major feature of the case against this person, that kind of lie may be actually very helpful, or at least not potentially harmful. So I think it matters a lot, and I think that the properties of evidence may be the critical part to look at. And I think at least some of what I've identified, hopefully seems intuitive, and you're saying, well, yeah, that kind of makes sense. But hopefully looking at it in this way it certainly made it easier for me to see a strong argument for these kinds of positions. So my hope would be that maybe this is helpful for people thinking about, well, say courts and attorneys thinking about, well, when should police be able to lie, and when does this pose a problem, or what should the law be regarding this? How should we should we, instead of saying coercive, should we think more in terms of something that fits with what I've described, but also in terms of training police, right? That I think this is probably given in the U.S. that it's legal, that I think how police are trained is really important, right? Because I think that there are tons of police that are trained in this interrogation technique. Border Patrol, Customs, people like that are also trained in this technique. And I've found that interesting, right, traveling now that I kind of notice more, right? And they do the same thing, right? And to be fair and to be clear, right, that they start by asking questions, right? And then they move once something kind of raises their concern, that they move to more pointed questions, and then finally the police interrogate when they're really convinced somebody's guilty, right? And that, to me, seemed fairly effective. I don't think that means they should be able to lie about whatever they want to, right? And I hope they would not want to lie about some things. But I think, there needs to be a structured way in which they can figure out what to lie about. But so my point about, customs, immigration, border agents, they are trained in a similar way, right? And they, somebody comes, I came yesterday, they said, what are you doing in Mexico? Said, well, I'm giving a talk, giving a couple talks and so on. And if I had answered in a maybe suspicious way, then they probably would have asked me more questions, right? And if that hadn't gone well, then they probably would have asked more questions. So, to be clear, I think these, to me, this whole line of how they do things is pretty fascinating, and it's a really challenging job, or aspect of their job. But I think when they lie and what kinds of lies they tell is really important. I think, it obviously has to be stressful for even an innocent person accused of a crime to be interrogated. So I do think false confessions happen. So summary is pretty simple model, and it can be helpful, it can be harmful, it depends, right? What I'm after was that we induce the guilty to confess, that we get the innocent accused to not confess, and sometimes this happens, sometimes it doesn't, and it really depends on the specifics of the evidence. Excuse me. And so that's all I have for this paper. I'll just briefly say, you know, I'm really interested in lots of practical topics in this direction. If any of you, you know, if you're practicing attorneys, if you're legal scholars, if you're economists, if you have something that you're like, oh, this seems interesting, you know, how does it apply to this? You know, talk to me afterwards. I would like to hear that, because it's always nice to, you know, hear other people's inputs on things that are important, because I'm an academic. I'm thinking about some things. I'm interested in hopefully shaping policy, hopefully shaping how people think about what I think are really important questions. Okay.
Thank you, Jesse. We still have a few minutes if someone would like to ask a question with respect to either the paper or some of the scholarly interests that Jesse has, because he really is his work is very cutting edge in the United States. This is really where economic analysis of law is going. Any questions? Yes.
Very surprised about your explanation. Where can I find your paper? Did you place your paper in?
Yeah, so if you go to my FIU webpage, there's a link to it. I can email it to you also. Either way, yeah, I'll just give you a card afterwards, and I can send me.
The first question.
Yeah.
The other question is, at the beginning you mentioned that in the part of the police work they can lie, but when they go to trial they can't lie.
Mm-hmm.
Maybe the first difference, you know, the first point, very important point in your paper. Why do you think it's so not so? They can lie in trial, but they can lie in the investigation.
Yeah. So why do I think that's the case? So I think after thinking about this quite a bit, I think it is to try to induce people to confess, right? So I think someone who, you know, maybe someone with a different way of thinking about this might suggest one reason for the distinction is that during interrogation it's still at the investigation stage, and there's still evidence being collected and so on. And when it's at the trial stage, or, you know, even nearing the trial stage, that they kind of already have the evidence, right? And it's about sharing of evidence. So I think, you know, perhaps police officers would, you know, and this is speculation, and I think it kind of fits with my thinking on it too, is that, you know, the interrogation's about trying to get somebody to confess, but it may also be viewed as trying to get evidence, right? And it's part of this collection of evidence phase, right? So one thing that I think people often say about, you know, may view about lying, you know, police lying to accused, and I guess I didn't include it in my talk, is, you know, people may say things like, well, if somebody's innocent, they should be able to, you know, stand up to, you know, being lied to. But that shouldn't sway them to confess, right? Maybe the same way that, people may say, talk about privacy issues if someone's innocent and, why do you care if the government knows, listens to your phone calls if you don't have anything to hide. It's different, but, just to be clear, it's a different issue, I think, but that may, I guess I won't get into that part, but I think it's said in a similar way, right? Well, if somebody's innocent, why does it, why do they, but it should just matter to them, that shouldn't matter if police lie. And I don't think that's correct, right? I mean, that's a lot of why I was concerned about this, and why I got interested. And I hope that came through in my concern about the potential for false confessions, right? So I think people are motivated by, there may be a sense of people saying I'm innocent and for the principle of this I'm going to, stick with it and not confess or, go to trial and so on. But I think there is also a sense in which people may try to just weigh their chances, right? And I think that's part of the interrogation process, right? The police are already convinced this person's guilty, and part of the process, I think, is to convince them that it's going to be a lot better for them to confess, right? And part of that, and I'm not saying this is, just by lying. I think just, my understanding of the way the process is set up, geared towards getting them to confess, and the, I think some of what's, often said is, that it's going to be like a weight off your shoulders. You're going to feel a lot better if you, just open up and tell us what's going on. That I think some of that's also said. So I think there is a sense in which there's this danger of false confessions, but I think there's also a sense in which some of it is about gathering evidence, right? So if you think about, for example, somebody confessing to, just for an example, maybe kind of gruesome example would be, somebody who's accused of murder and police haven't found a body, right? And the part of them trying to get the person to confess isn't just for them to say I did it, but also getting them to tell what happened, right, and where the body is, right? So in that case, I think police, and I think certainly people who train police would view this not just as being about getting a confession, but would also view it as kind of getting evidence. So I think that would be a distinction. But yeah, I think that's a good question. I guess I didn't really come back to that.
We have another question.
Yeah.
Yes, thank you very much for sharing with us your knowledge and practical cases. But
Thanks.
I have to ask you something about this kind of model, or it's not the topic, my question, but maybe complete. In Mexico, we try to follow the human rights. In this case, the model follow the basic human rights.
I think so. So I think, so I guess I don't actually know, so one thing we might think about, what fits for like the Geneva Convention for how people are handled. My guess is this kind of interrogation is not at all a problem. My guess is people are lied to in every country who are interrogated. There may be some countries where this, and I'll be honest, I don't know Mexico's law on this. I was actually going to try to look it up and didn't. So I don't actually know what the law in Mexico is on police lying to suspects. I suspect in most countries that is allowed, and whether it's legally allowed or not, I suspect it happens. So I think this is a lot less of a human rights issue than, some other interrogation questions that have been, in the last 10 years or so, have been issues. But yeah, I agree. My initial thought about this was, well, it is wrong to lie to people, right? That I don't like the idea of lying to people. So I'm sympathetic to that, and yeah, but I have to say I don't actually know what Mexico's law is on that, on lying to accused.
Thank you very much. I appreciate it.
No worries. Thanks.
Well, we're out of time, and we're very appreciative. Thank you so much, Professor Bull. It has been absolutely refreshing to have a chance to listen to you and to have a chance to look at a new way of approaching some of these questions. Thank you very much, Professor Bull.
Thanks again. I really enjoyed it.